Great, welcome. We have
Good afternoon. Good afternoon. Sorry, Sarah. This is Nichole, Atallah, and you just heard Sarah Nash, and welcome to the Internet Complaint and what to do about it. Good afternoon for those of you on the East Coast, and for those folks on the West Coast, good morning. We're happy to have you. Again, I'm Nichole, Atallah, a partner in our labor and employment practice at Mazza. I've been with the firm about 6 years now, and very happy to be here. I've worked with quite a few of you before, and I think we'll have a very interesting session today. Sarah?
Hi, yes, I work with Nichole in the labor and employment practice, and I've been in the field for the past 6 years or so, although I started earlier this year with the firm. Good to be here.
Great. Great. So just for those of you who aren't familiar with Mazza, we can go ahead and advance to the next slide. And just so that all of you know out there, I am actually on the West Coast this morning, and Sarah is humoring me and is on the East Coast. So we apologize for any hiccups, but I think it's going to go smoothly. But just so you know, that's kind of what we've got going on over here.
We're taking advantage of what the internet has to offer.
Exactly. So Mazza is a full-service law firm. One of our practices is the labor and employment practice, but we've also been serving government contractors for over 25 years and provide a full range of legal services on corporate, labor and employment, SBA procurement programs, and litigation matters. So we're happy to provide some insight today on the internet complaint and what we can do about it. So if we move on to our learning objectives for the day, today we're going to discuss scenarios where employees often experience employee complaints online. And the reason we thought this was a really pertinent and timely topic to bring to you all is that more and more we're getting calls from clients saying, you know, this employee posted something on Facebook, or they have a blog that's well known, or they have some other forum on the internet, and this information is getting out. And we're really concerned about what it does to our reputation, whether our clients might see it, what kind of information is being disseminated, what it might do to employee morale. So it's really, so one of the first things that we're looking at is whether or if you should do anything at all about it. And part of that is trying to figure out, you know, where we're seeing employee complaints online, what types of legal protections you might see online, and what types of things that we can do to really stop or reduce the likelihood that we're going to have some of these complaints aired in public forums. So some of today is going to be about legal protections, which is our field of expertise. And some of this is really going to be talking to you about successful strategies that we've been able to help clients come up with. Because at the end of the day, it's not just about the legal side of things. It is about it's about the practical side of things. So I'm going to put a polling question up to get us started, because I want to know from you all how many of you have ever had an employee complaint online. Some of you might be just expecting it at some point in time, and it will very well happen at some point in time. But many of you likely have already experienced this. So we wanted to get some feedback from you as to whether you have experienced this yourself. Let's just wait for a second. We've got a few people still straggling out there. So we're going to close it. It looks like it's about 50-50. So it looks like about 50% of you have had complaints already posted online, and 50% of you are just anticipating that it may happen to you at some point in the future. So let's talk about, for example, some examples. Let's move on to the next slide and talk about some examples of where we have seen internet complaints occur. So the biggest case in the last year that we saw was a sexual harassment complaints being aired online. And I don't know if you guys recall, I think it was from the fall, or maybe even last summer even, the Uber debacle that essentially brought down the CEO of the company. But it started with this blog that a former employee posted. And it was all about, how the kind of pervasive sexual harassment and sexual discrimination, the quid pro quo sexual harassment and sexual discrimination that was occurring at Uber. And again, that wasn't even a current employee, but look at what a nightmare it was for the company. There was not really a whole lot they could do about it. It resulted in a huge loss in ridership for the company. And so one of the questions that Uber was asking itself, it was kind of a what not to do in HR, really, if you look at it closely. And what Uber really needed to do was step back and say, how do we immediately address some of these pervasive issues? These pervasive issues were not a surprise to Uber. People knew that they were happening within the company. And unfortunately, for whatever reason, either the human resources machine or the culture at the company was not able to adjust in order to prevent a former employee from kind of airing the dirty laundry out there. It would have been much better if they could have handled it while that person was still employed by the company or sensing the culture of the company needed to change.
Another example is that's common because most of us all have them, Facebook accounts. Maybe you've seen the headlines showing employee posts, I don't know, some obscene, offensive commentary to a Facebook post, and next thing you know, there's public outrage and he is released from the company. But what happens when these comments are directly related to working conditions? This is when you might have to stop and think about what actions an employer can actually take. If someone's complaining about their wages or about an unfair supervisor, there's an extra step that might kind of impose certain protections on employees. And obviously, these are especially sort of risky topics for an employer who might have customers or other workers or the public who is able to see these comments. So there's a lot of embarrassment that might be wrapped up in certain posts, but a lot of them are protected. So something to think about.
And then one of my favorites is Glassdoor, because I think or Google reviews or those types of websites that allow employees to essentially review their employers online or provide feedback. And Glassdoor, and if any of you have had certain situations with employees complaining online and you want to give us the two-liner in the Q&A box, we'd love to see some of these examples from you. But employees often go out to Glassdoor and they don't have to put their name on them, and then prospective employees will go and look at those. So one question we get is, how do we get Glassdoor to take it down? Well, Glassdoor generally will not take it down. And so then the question is, just like we see on TripAdvisor for reviews of hotels, the question is how or whether the company wants to respond. I mean, if Glassdoor is a place where you can reasonably expect prospective employees to go and look and evaluate whether they want to come to work for you, then it may be worth responding to the Glassdoor complaint. Now, we'll talk about this in a little bit. I wouldn't ever tell you to just go up and say, well, this employee was a crappy employee and blah, 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 blah. We want to think very, very carefully about the best way to respond, to really reflect the integrity of your company and not give too much credence to somebody who may not have any idea what they're talking about truly. So that's one thing we'll talk about today in strategies to responding to those things.
Another example that is not quite as prevalent is investigations initiated by agencies or law enforcement. And many employers, I'm sure many of you listening today, have agreements in place where you essentially ask your employees to sign confidentiality agreements. And the understanding then is that once they sign these confidentiality agreements, they're not going to go talk about confidential company proprietary information with outside third parties. But the question does arise when a law enforcement or law agency is asking your employees about these confidential information, whether employees are permitted to share information that they've already promised that they won't. And there have been some cases recently that say, yes, it's in the public interest, essentially, to hear what these employees have to say, regardless of a confidentiality agreement. And in fact, if the confidentiality agreement is written too broadly, it's not enforceable at all. So unfortunately, just because you take the right steps from the outset and try to protect certain information, it doesn't necessarily mean that it is protected. And this is something that's, I think, appearing more and more, and it's unclear how the courts will go, but at least in California, it's a very eminent threat.
And it's kind of the same rationale with court documents. And court documents now are often posted on online filing systems. They certainly are if they're federal. And in most states have an electronic court filing system, which means that you can find these documents through certain search engines and by logging in to different state or federal repositories for court documents and find out whatever an employee might say in a complaint. And one of the first things, it's bad enough if you're wrapped up in an action or if you're just named in a complaint that's not even about you or you're not a party to the case, but perhaps your name shows up in a pleading somewhere. There might be things in that pleading that you're not particularly thrilled about having in that pleading. Can't really do much about it, but we need to talk about what kinds of statements are made in public filings and whether there's really anything that you can do about it. So these are a couple of scenarios where we very commonly see internet postings. And again, as we saw with the Uber case, there are blogs, Facebook, all sorts of ways. Employees can set up websites. They can have their own businesses. So it's really common for employees who are frustrated and don't feel like they have an outlet within the company to address the concerns to turn to the internet, right? The internet is our most accessible best friend in times where we are, not feeling fantastic. It's an outlet. It's something that's accessible to everyone. And that makes its accessibility makes it also something that employers need to be paying very, very close attention to. Okay, let's go on to the next slide and talk about the types of protections that are given to employees. We're going to spend a couple of slides talking about the employee protections to really lay the framework for some of the strategic goals that you might want to pursue. And I've listed them here just so you can see kind of all together the world of employee protections. And by the way, this isn't an exhaustive list by any particular stretch. It is just kind of the big ones that we see often. There are lots and lots of, as Sarah will talk about later, kind of state laws or state protections. So you really need to look at this on a state-by-state basis and evaluate what the complaint is, where the complaint is posted, how it's posted, and whether or not it triggers some obligation for you to proceed with caution. So let's go to the next slide and really dive into some of the legal protections for employees. And keep in mind as we're going through these, each of these could be a webinar in and of itself, if not a half-day training. So we're really going to focus today on what about these particular laws or regulations should make you aware to alert somebody or to get some help if an employee complains about something that might be implicated by one of these laws.
Right. And remember, this is just we're lawyers. This is the legal side of things, and those are important. But later on, we're also going to talk a little bit about from just an optical perspective. Just because you're legally allowed to do something doesn't necessarily make good business sense. So this is the legal side. Later will come the public relations side, I guess we could call it. The National Labor Relations Act is one of probably the most likely law. I don't know if that's, well, I'm going to say, I think that's the most likely law that you might run into when you come across internet complaints. It's definitely the first thing I look for when I hear about something that's gone on the internet and an employer is wondering, what can we do in reaction to this? This law, it's a law that governs labor relations in the U.S., and that's somewhat misinformative because it covers all employers engaged in interstate commerce, not just unionized workforces. So whether your employees are unionized or not unionized, these laws still form the basis of certain rights for employees. And one of the rights that's provided by this law is the right for employees to engage in concerted protected activities for their mutual aid or protection. What does that mean? It means any activities that employees are coming together, concerted, that means coming together in a group action, or at least the contemplation of a group action, to kind of support their terms and conditions of employment. And terms and conditions of employment is anything from sharing information about their wages to complaining about certain policies or managers, displaying maybe union-related logos or insignia, or just saying that they support a labor union. Pretty much anything that relates to what an employee engages with in the office that could be seen as terms and conditions of employment. And under the NLRA, the National Labor Relations Act, employees are protected to discuss these things. And this discussion and this protection for talking about these topics extends to internet complaints. And there's a recent story I was reading about a restaurant employee who posted the need for the company to have a better sick policy. And in this post, he also went on to say that because they didn't have a good sick policy, they probably had contaminated food in the restaurant. This probably would make any restaurant owner gasp, and obviously the employee was disciplined. I think he was terminated. But afterwards, the employee's post was found to be protected activity. Because he was posting about this sick policy and because his concerns about food contamination were reasonably linked to these terms and conditions of employment, this was found to be protected activity. So you want to be careful when an employee does make an internet complaint that their complaint isn't a protected concerted activity under the NLRA. This doesn't mean that an employer can't regulate employee speech at all. There are some things that are not protected. Blatant lies about an employer are unprotected. Obscene speech is unprotected. But an employer should carefully look at the way that it's drafting policies to make clear what is protected and what's not protected, or at least what is tolerated by a company and what's not tolerated by a company.
And that's the hard part, right, Sarah? I mean, the hard part is, how do we really tell if something is linked, right, or reasonably linked to the protected activity? Because if I was that restaurant owner, my first thought would be, what does sick time or sick leave have to do with food contamination, right? Like, if you really dig deep, I guess we can make the connection. But if I'm just your average business owner, I'm thinking, no, that's not linked at all. But there is a whole series of the Facebook cases from like 5 or 6 years ago and other cases out there that really, really give the benefit of the doubt, I suppose, to the employee with respect to how it was connected. Although a couple of those cases did turn against the employee and said, there were some posts about supervisors that really had nothing to do with the working conditions and was just posed to be mean. There are a lot of cases around things like actual harassment and bullying and things like that. So you really have to piece through these postings, and that's where you should, if you're at all concerned, make sure you talk to counsel or someone within your organization to really vet these to make sure you're kind of on the right side of the action.
And judges are humans, so they're looking at the same facts and they're making these determinations based on their own personal experiences and their preferences. And I should mention that in that case, it's interesting because they drew the link saying that because employees weren't permitted to take enough sick time, they were forced to come to work sick. which was more likely to lead to contaminated food if you have unwell people handling the food in the restaurant. So that's just, yeah, like Nichole said, it's anyone's guess how some things relate to other things. But if you can find a link, you're a little bit, I guess, under the threat of a unfair labor practice from the National Labor Relations Board. That's the entity in charge of enforcing the NLRA. So we talked about a little bit of how employers can protect themselves from these sort of things. It's interesting because when you have a handbook or you have a social media policy, those are also in danger of running afoul of the act simply by virtue of chilling employee speech, chilling or maybe dissuading an employee from exercising their right to talk. So one thing that we do here at Polera Mazza is we advise employers on how to responsibly draft handbook social media policies so that they, on the one hand, encourage employees to be responsible about their internet participation, but on the other, don't infringe on their employee labor rights. And so, yeah, go ahead.
So what we see a lot is policies, like a social media policy that will say something like, you are not allowed to say the company's name in connection with an internet post, or you are not allowed to talk to the media under any circumstances. And what the company is really needs to say are things like, you're not allowed to speak on our behalf. You're not allowed to speak as a representative of the company, or if you ever say the company's name, you need to make sure that you clarify that these are your own statements. They're not statements on behalf. Things like that really qualify, because it's really tempting to say, well, we're just going to tell them not to reference us at all, or not to talk about their work. But we can't do that. We have to be more careful than that.
Right. As long as you can, at the end of the day, tailor it to something that is actually a business need or a business legitimate reason, you're often safe. But you can't, whenever you're drafting these things, you want to remember that employees have a right to talk to third parties, right? And that includes the media, that includes coworkers, and even in some instances, customers. And so when you're drafting these, you have to remember what it is specifically that you're preventing them from doing. So, for example, disclosing business secrets. Pretty much everyone agrees that's something that's protected. So if you're going to draft it, make sure it's clear that that's the sort of thing when you talk about confidentiality, and it doesn't apply to, for example, employee pay rates or payroll information. Another sort of, in the internet scheme of things, it's sort of an interesting thing to think about is policies that prohibit employees from befriending coworkers on social media, or trying to sort of circumscribe the way that employees interact on the internet, can also be found unlawful. So you just want to make sure. It might be tempting to say, okay, well, I'll just tell them who they can talk to on the social media or Facebook, but that's also been found unlawful in many instances. You just want to, like we said, make sure these policies are drafted in a way to remind employees that it's important to be responsible, and they need to remember that they are a part of a community when they're posting anything. I mean, it's sort of what you would say to your kid, right? Like, remember, when you go online, people can read it. And so that's the NLRA. If you have any questions, please let us know. But let's go on to the next sort of interesting reason that employees can't talk about or are permitted to talk about certain things.
Yeah, so I lumped all of these together and just called them retaliation provisions, because there are pretty much every law that gives employees protections also includes some sort of provision for anti-retaliation, right? That you're not going to retaliate against an employee for complaining about any number of these things. And so all of the Title VII stuff, which is your race, gender, national origin, religion, all of those things in Title VII, your age under the ADEA, the Age Discrimination and Employment Act, OFCCP for government contractors, so that's the Office of Federal Contract Compliance Programs, and that basically is, you know, the EEOC of the government contracting arm, and so they have a lot of anti-retaliation provisions as well if someone were to complain to them. Anyone with disabilities, family medical leave, workers' compensation, and that's a very state, the workers' comp laws are state-driven, but many of them have anti-retaliation provisions. OSHA under Section 11, and there are more because there are analogous state laws to all of these federal laws, and then other state laws also protect employees. So we're always thinking about the federal laws, and then the second question we would probably ask you if you were to call us is, what state is this employee in? So we can make sure that there isn't some other law out there that would implicate or that we need to consider before making a decision. One common question, so the obvious thing is, let's say an employee complains about bullying on the basis of their religion and says on Facebook and says the company doesn't do anything about it, they're horrible, I don't know what to do, et cetera, and you know, at very least no one should go to work for this company. And you are just outraged. That would be the obvious scenario where you don't want to retaliate against somebody for making a complaint. You also want to make sure that you look at that your complaint policy is drafted in such a way that would give you some flexibility to say, you have some avenues for complaining. You were supposed to follow these processes. Why didn't you follow these processes? So you always want to be looking at your complaint processes. I think in the last couple of years, we have really gone to a system where we just say, contact HR. And if you can't contact HR, move to something else. And we'll talk about in a little bit why you might want to consider with certain workforces, not all workforces, but you might want to consider having a little bit more structure to those policies, or at least having specific contacts listed in the back of your handbook so that employees can, without question, know exactly what their avenues for complaining are. But again, if somebody were to make a complaint like that online, I would be very cautious for a number of different reasons to automatically discipline without seeking counsel and really unpacking all of the reasons. So that's kind of I would consider that one of the more obvious scenarios where someone might complain and you think to yourself, oh yeah, there's a retaliation provision, I should probably seek help. One thing that's a little bit less common, but I've seen more and more in the last couple of years, is someone that is not the subject of the discrimination or harassment or the problem, whatever they're having, but they complain on somebody else's behalf. So Mary complains that Joe is being harassed and bullied, and Mary's distraught about it. Well, Mary is now protected because Mary complained on Joe's behalf about some sort of protected activity. And now Mary is also protected from retaliation. So we need to, again, it doesn't mean that Mary can't exceed the scope of what she's allowed to do under those laws and under that protection, but we need to be very careful about how we do it. And honestly, most of the time, this is when employers call us to talk about discipline, it's not just the complaint itself. It's also usually that Mary's not performing, and now Mary brings up a complaint. What do I do? So these are very complicated scenarios that we need to kind of unpack and really talk about risks to the organization. And we realize that they're complicated, which is why we're talking about this today. And you really need to think about, when we're talking about these things, you really need to think about what your company culture is, because that will drive how your policies are created. I think one of the tendencies is to, we've always had this complaint procedure in our handbook, and so we just keep following it. But your company culture doesn't stay the same over time. So every year you should be looking at your policies and practices and saying, okay, does the policy that we created 10 years ago still seem like it's the message that we want to be sending to employees about how we handle complaints, about how we handle investigations, about what kind of support we're going to give to employees. And we'll talk about this again a little bit more later, but that all feeds into this idea that we want to some degree make employees feel comfortable to complain to us before they complain to the world kind of writ large. Let's move on to kind of other whistleblower protections, because I think these are kind of the hot topic du jour.
Yeah, it's a great segue, because often with whistleblower protections or whistleblowers, you have these people who kind of enter the international stage airing their grievances or airing, I guess, violations of law that the companies have committed, and they're letting everyone know. So if there's a way to keep these complaints internal, it's typically the better way. You always want to be the company that was responsible for stopping some sort of illicit behavior, not the one that silenced the whistleblower who brought it to your attention. So there's a really wide web of whistleblower protections out there, and many state and federal laws protect employers who disclose information about suspected unlawful activity, and these are the whistleblower protection laws. And pretty much every state has some sort of law that protects employee whistleblowers. It's often not even maybe a statute, but it might fall under a wrongful termination case law. But the state laws typically find that a termination of an employee who made a disclosure to law enforcement about some sort of public policy danger, they're protected from the general at-will employment rule. So these state laws are out there. Wherever state you're in, you should look at them before you take action. They're typically only when employees apply to law enforcement, and so it doesn't come up as often as you might expect or you might see in other federal whistleblower protection laws out there. When you look at the federal laws, you have laws that protect private employees and laws that protect public sector employees. And under the government, we have two here. There's actually 3 different laws you want to keep in mind. One is everybody's favorite False Claims Act, which essentially provides protection for someone who discloses waste, fraud, or abuse against government resources. And then you have the Whistleblower Protection Act, which is only protective of federal employees. And the reason that the Whistleblower Protection Act is particularly interesting is because in this realm, it protects not just federal employees who report to their supervisors or who report directly to law enforcement, but it also protects employees who report to the media. Essentially, the reasoning is, under the law, employees are allowed to make disclosures to Congress, and the idea is if they're talking to the New York Times, for example, ultimately it will get to Congress. So for better or for worse, this is the rubric that we operate within. And under the Whistleblower Protection Act, sort of modeled after it, is the National Defense Authorization Act whistleblower provisions, which apply to contractor employees. And they essentially apply many of the same rules regarding protection of disclosures, whether it's for disclosing bad management or gross waste of funds. Those disclosures are also protected. And it looks like, although it hasn't been around for that long, the same media protections apply. So if you have a contractor employee who discloses some sort of violation of law to the media, they are presumably, or they can be protected. So that's the public sector employees. On the other side of things, you have a lot of whistleblower laws out there that apply to private sector employees. And one of the most, popular is the Sarbanes-Oxley Act, which protects reports of violations related to shareholder fraud or violations of security laws. And a couple years ago, there was a case. It used to be that this was really only relevant to publicly traded companies. But recently, there's a case that said, essentially, if you're a contractor that's providing services to a publicly traded company and you happen to be privately owned, you can still be held accountable under Sarbanes-Oxley whistleblower protections. So everybody gets to worry about this law now.
And just to interject for a minute, if you're really interested in whistleblower protections and want to know more about the coverage of some of these protections, Sarah and Cy Alba, partner in our law firm, just did a webinar, I don't know what, Sarah, a month ago on this, and you can find that and all of the resources that Pleromaza offers on our website under the resources tab. So please feel free if you're interested in this stuff, not just in the context of internet complaints, but just understanding whistleblower protections in general, to go out and listen to that webinar as well.
Exactly. And there's a lot of whistleblower protection laws out there. They're related to environmental or consumer protections. Affordable Care Act, I believe, has a provision. So you just want to be aware that there's a lot of different topics that might fall under their protection. And it's not really a whistleblower law, but Nichole alluded to this earlier. There are other state laws, for example, that protect employees who participate in off-duty conduct. So I think it's California, North Dakota, and Colorado, and to some extent New York, all have laws that say you can't discipline or not retaliate. You can't create an adverse action against an employee for participating in lawful activities that are conducted outside of work. And so you want to be aware of these other laws that might impact your state behavior. There's also some laws in some states that prohibit discrimination based on political affiliation. So there's always some gray line when you're looking at posts and seeing what employees are posting about. Those are the summary of the laws. Do you have anything?
Yeah, and I think that what maybe our point is that there's so much out there. Sarah and I, who work on this stuff full time, still are constantly looking to see what's happening at the state levels. We're looking to see whether there are laws that might cover certain conduct, because there's just so much out there. And so for you all who have, parts of your job that you have to do other than just watching what's happening to laws in this country, it's really, really, really a challenge, and we sympathize with you all. And so the question now is, what do we do about it? Like, what do? We have this whole world. Are we afraid to do anything? Are we powerless to do anything? And the answer is no. You're not powerless. So we're going to move on to now that we've broken you all down, we're going to try to build you all up again. So I did get a question about a comment we made earlier about prohibiting people from being friends with other employees on Facebook, whether or not you're a supervisor or not. And the question was, are you saying that employees can be friends with their bosses on Facebook? And there's nothing really that prohibits doing that. If I were an employee, I don't know that I'd want to be a friend with my boss always on Facebook. I think there are good reasons not to do that, particularly because if you're an employee, you expose yourself to a lot of possible issues. But as an organization, and whether you want to prohibit that, I suppose it would depend on the level of supervisors, and I would venture to likely recommend, I'd have to look at the specific situation, but I would impose that duty on your managers, and be very, very clear with managers as to what you want managers to be doing as far as their interaction with other employees. But again, a lot of it depends on what type of supervisor we're talking about, what the relationship is between employers and supervisors, et cetera, et cetera. But in general, it's hard to prohibit employees from interacting outside of the workplace. And I think that segues into kind of a discussion about strategies and thinking about how you want your company culture to look and to feel. because that's one of those questions that may have some legal components, but it also has a lot of employee morale components, and how far you as a company really want to get into regulating the outside work conduct of your general employees. There are lots of reasons why you might want upper level management not to socialize a lot with other employees, but a lot of companies have stopped prohibiting that in general. So that could be a company culture question as well. So how do we reduce the likelihood of these complaints in general? Because it's a lot easier to deal with this stuff on the front side than the back side. So if we can reduce the chances that we're going to get a complaint, we're all a lot better off. And the first thing I always say is you've got to tone from the top. And if you're an HR professional listening to this webinar, you will. The number one complaint I get from HR professionals is that I can't do it alone. I have tried to shift some ways that we work here. I have tried to talk to managers ad nauseum about open door policies or structured, kind of creating some kind of structured method for complaint processing, getting back to people, et cetera, to no avail, because they don't want to listen to HR. Or, my C-suite of folks is not really on board with what I want to do. And sometimes they're not going to be. I think it's a company decision that when you decide that you want to change a culture in your company to be more welcoming to employees, that's how you get employees to kind of complain to you. It doesn't mean that you let employees run the show necessarily, but it does mean that you've created an environment where employees feel like they can come to you, that their concerns are going to be addressed, even if it's not addressed in the way that they want them to be addressed, that somebody's getting back to them, they feel heard, they feel like an open door policy is something that you really believe in, as opposed to just something you say because it's the thing to say, right? And you hear that feedback from employees all the time. We do quite a bit of collective bargaining negotiations. So we're in the room with the employees that are representing the workforce in bargaining negotiations, and we hear those complaints often. We'll be sitting at a table, and employees will say something, and the HR person that's sitting next to me or the CEO that's sitting next to me will say, well, why is this the first time I'm hearing about it? Essentially you guys went and organized over X, Y, and Z, but why is this the first time I'm hearing about it? There was something in that culture that made it seem to those employees like they couldn't come and talk to you, or they shouldn't come and talk to you. And that's especially difficult for government contractors, because many of you you're walking into a workforce situation where you may be picking up an incumbent staff quite a bit of time when you take over a contract, and there are emotions tied into that previous contractor that you've got to deal with. You've got to deal with changes in terms and conditions of employment, which may not be popular with employees. And then you're at the same time trying to, while that employee is working at a government site, you're trying to impart your company culture on those folks. So there is no doubt that as a government contractor, you have an uphill battle by far. So it makes it really, really important that when you're on site with employees, that everything about what you do, when you make that decision about what your company culture is going to look like and feel like, that it permeates in every single thing that you do, so that employees understand, okay, this is the policy and they mean it. So if you tell employees when they complain that you're going to get back to them, somebody gets back to them. Even if it's to say you don't have an answer for them. I can't emphasize enough how many times employees will say, but nobody responded. And so they're just sitting at home festering, right? And trying to find that outlet. So it's really, really critical that you do what you say you're going to do. And I'm not here to tell anybody what their company culture should be, but I do think it's a really important thing to sit down and actually talk about what we want that culture to be and how we're going to make it happen, and how we're going to make sure that it has to come from the top and it has to really be pushed down. And it's by far one of the most difficult things to make happen, and it requires that everyone in the company is on board and understands culture. Take a look at your complaint or grievance procedure. I alluded to this at the beginning of the webinar, but the tendency has been over the last couple of years to just say, contact HR. Well, if your HR is more than one person, that doesn't always tell people who they should contact. And you want to do this for a lot of different reasons, not just internet complaints, but for the purposes of any type of complaint under like Title VII or the ADA or the ADEA. You want to make it very clear what your process is for complaining, so that it raises all sorts of good defenses in if a case were ever brought against the company, if the person didn't follow company policy. So it's a really good idea to look at your complaint procedure with fresh eyes. Have somebody that hasn't looked at it in a while read over it and think about, okay, what is the tone of the policy? Is it an angry tone? Is it an inviting tone? What kind of tone do you put in there? What kind of words do you use? And do you want to provide some structure that makes employees feel like, okay, they didn't just put this policy in there because they were given a template. They put this policy with real thought as to how it should apply to their organization. Those words on that page, when employees need to go complain and they look in that handbook, they're going to, you sense that invitation. We've looked at enough of these policies to really tell when we can sense when you've just pulled a template and when you've really applied it to the culture of the organization. And so it's really critical that you not only draft it to adhere to the culture of your company, but that you then follow through with what you say you're going to follow through. So if you tell employees you're going to get back to them, get back to them. Some companies are actually going to more structured grievance procedures. I don't think that's the right formula for all companies, but I think it's a really good, it's really something you should consider going forward. Put it on the table for consideration, and if it doesn't work with your culture, it doesn't work with your culture. But that gives you all, even if it's an internal policy that's not put in a handbook, it gives your people some sort of sense of our commitment is to get back to complaining employees within X days. Or this is our method for determining whether we have some employee morale issues and what we're going to do about them. You may sense something happening before an employee ever complains, right? So how are you going to deal with those things? It doesn't have to be a policy in your handbook. It could be an internal policy that you have. You want to make sure that you investigate all credible complaints. So sometimes you'll get, I had an issue last year where a client got an email, I don't even think it was an email, they had a complaint box, and there was a complaint put into the complaint box, but no name, nothing identifying, and it was kind of a we don't like our benefits situation. Well, there was really nothing the employer could do about that. I mean, it's kind of like, okay, well, you don't have really anything to investigate there. But if you have credible complaints, you need to investigate them. And I don't mean, you need to necessarily go hire a company to investigate the complaint. You just need to walk through and take reasonable steps to make sure that you've talked to some people that you need to talk to, that you've addressed it, and that you get back to the person who complained with some sort of resolution, even if it's not the resolution that they wanted. Even if you get that employee who's like the classic complainer, and pretty much everyone's had one where they're just a classic complainer, right? And you're annoyed by them, and you're like, this person just complains to complain, and roll your eyes. That person is complaining to other people, and it really affects your morale. So you may have to spend some time with that person addressing their complaints. And I know it gets really, really annoying, and there are gentle ways to tell the person, are you satisfied? Let's really think through our complaints before you make them, that kind of thing. But you don't want to chill people from coming into you and talking to you about things. And keep in mind that how you respond to that kind of complainer really permeates throughout the organization. So it's a good idea to just kind of suck it up sometimes and keep getting back to the person. Be cautious about disciplining protected employees. So if somebody has made a complaint, you want to look at, okay, what's the time frame in between the complaint and the discipline I want to levy? Have I disciplined somebody for something similar? So as I mentioned earlier, most of the time when we're talking about discipline, we're not always talking about disciplining for the post itself or the internet complaint itself. We're talking about some other type of performance issue or attendance issue. But we need to make sure that we're not treating that person more harshly because they did make some sort of complaint or they did complain on the internet. And for, one perfect example is if you get a glass door complaint and the person didn't identify themselves, but you are sure that it's Joe, right? You are 100% sure that it was Joe. And all of a sudden, Joe kind of messes up an assignment. You need to make sure that your bias isn't getting in the way, that you're not disciplining Joe more harshly than you would discipline somebody else, because that could be the basis for a complaint. And so when the first things we'll ask you is, are there other examples of somebody who's engaged in this kind of performance deficiency, and how did you discipline them? And that, by looking at those comparators, you can try to rule out your bias as much as possible. We're all humans. We all have emotional responses to things, and that's completely normal. So we kind of have to build in ways to check yourselves, and that's a lot of what we help employers do. All right, Sarah, do you want to talk about responding to complaints?
Yes, perfect. And Nichole, you talked about this before, but it's company culture. How are you responding when someone submits we say credible complaint, but maybe sometimes you don't think that a complaint is credible. You think it's gossip. You think it's completely unreasonable. This person is being difficult, and there's no reason that you should need to respond to this. But sometimes, depending on the circumstances, you need to think about it and decide whether a response would be reasonable. And so sort of the best advice we can give is to slow down and look at the facts in front of you. There's never been a case that was heard that I can think of, at least. Maybe Nichole has some different experience, but where someone took an extra day or week to look at an employee's behavior or look at a complaint and wait and see what the appropriate reaction should be. And the way you do that is you sit back and you say, what do we need to do to assess this complaint? First of all, you need to consider public relations, right? So if this is a Facebook post, for example, is this the sort of thing that you want someone to respond to? You want someone from the company, maybe the CEO, to respond to? Or is this maybe a supervisor would be sufficient to respond? These are things you want to consider when you're looking at this complaint and you're looking at the public optics of all of this. What makes the most sense? Not even from a legal perspective, but from a company relations, employee relations perspective. How do you want to respond? If you want to respond. Another thing you need to do, this kind of goes hand in hand with investigating, but you need to make sure that you gather all the relevant facts. You want to talk to the right employees. You want to talk to more than just company representatives. You want to make sure you talk to employees involved. You want to confirm that your process has been followed. If you have a handbook that lays out sort of a guidance or a practice for how you do this, you probably want to follow what the handbook says. And when you're gathering facts, remember what documents might be relevant, what facts you have access to. Don't just make a couple phone calls and assume that that's sufficient. You also want to look at the severity of the allegations. Is this just office gossip that's not really going to go anywhere? Or are there severe legal implications that could really implicate the company down the line? And if there are severe legal implications, you really want to make sure that you're addressing two things, right? Your response to those, the complaint or the possibility of a violation, and the complaint itself. And so often employees can be the best people, the best representatives to be on the front lines to see what's going on. So they really might have some good information. So you should listen to your employees and investigate what they're telling you. And sometimes the importance or the severity of allegations will really be tied to the organization itself. For example, if you have a mission that really values, I don't know, veteran rights, or you have maybe a religious mission, you might put that into consideration too when it comes to figuring out how you want to respond to some of these things, because your image is a big part of who you are, and customers, workers, and other companies are going to be watching. And of course, as always, we went over the laws that might be implicated. There are a lot of them. Make sure that whenever you're looking at a complaint, responding to a complaint, make sure that you understand what laws might be implicated, just so that in your response you can either address this other laws that are implicated and understand why they are not going to be in your way, essentially, why you're not going to be violating laws by responding the way you are, or understanding what actions you do need to take moving forward.
So I always like to include just a couple of slides about, staying positive and staying cool, and that kind of goes back to some of what Sarah said about just slowing down, kind of just, and if you're an HR professional, what I usually hear from HR professionals is, well, the CEO or a manager or somebody in the organization is just livid and wants this guy gone. Well, and I tell them, and sometimes I've got a lot of times we have the CEO or the manager or the whole team on the phone, and we just kind of want to slow down that emotional response a little bit. There is a lot of opportunity out there to turn negative reviews into and manipulate them into strengths about the company. And the opportunities for this are usually when I see a Google review or a Glassdoor review. And I like to compare this to when I'm going out to look for places to stay on TripAdvisor. So when I'm going out to look at the reviews on, say, a hotel in Mexico or something, this is my dream vacation. I'm just kind of talking you guys through. So, if I'm going out to look at the different hotels I might want to stay at, and I see that there are some negative reviews, I read the negative reviews, and I also look at the response. And I look at the response to see whether the company might have personalized it, whether the company addressed the concern, if the company owned up to a mistake that truly was there, whether they said, what they said and how they responded and the tone that they said it in. So a lot of times, say you get a complaint, this is a terrible company to work for, I'd never work for this company, they have horrible benefits, and they lied to me about what I was doing, what job I would be fulfilling. And I've seen these kinds of complaints over and over and over again. And the opportunity is there for you not to necessarily feed into that negativity and say this employee was awful, this employee didn't know what she was doing, or whatever it is, and really just say, something to the effect of, we regret that you had an unfortunate employment decision or an employment experience with us. However, our company prides itself on, and then just enter in your statement, right? Because you want that employee, the prospective employee, the employee coming on board and looking at these reviews to say, well, maybe that person was just a little bit nuts, right? Because whenever I look at TripAdvisor or Yelp, I understand that there are going to be more people that are complaining than are positive, because when we're angry, we're more likely to go and leave a bad review than if we've been really, really happy with our experience, right? That's just the human condition. So it's a good idea to kind of counter with positivity, again, if you decide to respond at all. There might be some online reviews that are so outlandish that, you just say, it speaks for itself. But I really think it can be beneficial in certain situations to see a company respond in a very positive way. It tells me that they're engaged and paying attention to what's happening out there, which can send a good message. Try not to be defensive. I know it's tempting to go into each and every allegation and explain why you didn't do a certain thing, or not us, or we did. Again, we want that really positive spin on things as much as possible, and not to appear too defensive, like we did something horribly wrong. We talked about investigation, and again, you know, come and talk to us or your counsel, whoever they might be, and talk through like how whether something is an appropriate response from a legal perspective, right? Because we can help you walk through whether responding in a certain way is going to get you into legal trouble. And finally, because I know we're reaching the end, so I'm going to go to the last slide just very quickly. This is just your cautionary tales, right? Don't retaliate or appear to. Appearances mean a lot. Try not to violate any other laws in responding, right? That's a big one. Consider defamation, slander, and libel. And this goes back to what I said about being careful about what you say about a person in response online, because you don't want to set the company up for some sort of defamation claim. And you're always thinking beyond today, because internet complaints and news in the world we live in are just a snapshot. And you want that snapshot to be something that's pretty short-lived, so that the company can go on to something more positive. Your goal is to grow the business, not to focus on this stuff. It's really important to address it appropriately so that it goes away and you don't end up being like the Uber of tomorrow. Or I could name a bunch of different companies that have had issues this year with internet press. So again, if we respond appropriately and we respond cautiously and give thought to what laws could be implicated, then you can address these things and move on to bigger and better things. So we want to thank you again for your participation in today's webinar. If you have any questions at all, please feel free to email either Sarah or myself. I think we addressed most of the questions that were posed throughout the webinar, but if we missed something, please let us know. We really enjoy doing this. It's a nice break from the daily slog for us. So please feel free to ask us any questions, and we love getting your feedback. Have a great day.
Thanks, everyone.